Attendees are in listen-only mode.
Hello, welcome to AICP Exam Review. My name is Benjamin Lee, and I'll be moderating the session for today. If you have any questions, please feel free to ask those in the questions box, and we'll be able to answer those after the presentation. And I would like to introduce the speaker for today. Gary Taylor is an associate professor and extension specialist in the Department of Community and Regional Planning at Iowa State University. He publishes, conducts workshops, pursues projects, and provides assistance to citizens and government officials related to land use planning and land use law. Mr. Taylor is a member of American Institute of Certified Planners and serves as a professional development officer for the Iowa chapter and American Planning Association. He holds a law degree from University of Nebraska and master's in community and regional planning from Iowa State University. And now I'll send it over to Gary. Hi, Gary.
Hi, Ben. Thank you. Good morning, everyone. Hopefully our technology works this morning. It looks like we're doing okay so far. As Ben said, my name is Gary Taylor. I am the PDO for the Iowa chapter. I teach planning law course and work with communities across Iowa. The topic this morning obviously is planning law. What we are going to cover, if I can advance my screen, what we will cover, there we go. We're going to cover primarily cases that are associated with planning law, land use and planning law. We're going to start by taking a look at the powers that local governments have to regulate land use, where those powers come from. There's a good chance that there's going to be a question or two on the AICP exam about these issues. I like to think of it as really the limitations on those powers. When you start talking about constitutional cases, cases that are decided by the United States Supreme Court, those are decided primarily on constitutional grounds. They are defining what the limitations are on local government authority. So we will cover what generally constitutes the bulk of the law questions on the AICP exam when we talk about these cases. We'll talk about some federal legislation that implicates land use, a couple of federal acts that you all are familiar with, the Telecommunications Act, the Religious Land Use and Institutionalized Persons Act. We will talk a bit about those. And then there are some miscellaneous cases that are generally associated with land use that have a good likelihood of showing up on the AICP exam but don't actually fit neatly into either of the first two categories. When you look at the breakdown of test content, if you're looking at your AICP exam bulletin, you'll see 6 substantive areas of the exam. What we're not going to cover are issues associated with plan making and implementation and functional areas of practice. If you look at the breakdown in the exam bulletin, you'll see that it lists topics like land use development regulations, zoning, subdivision controls, for example. You will also see that it talks about growth management and growth management tools. We're only going to cover those topics to the extent that there are some cases associated with those topics. The mechanics of growth management, the mechanics of zoning really are going to be covered in plan making and implementation. When we get about halfway through, I think we will take a short 5-minute break to give everybody a chance to stand up and stretch your legs. But having said that, keep in mind that history, theory, and law, the history, theory, law portion of the AICP exam is only 15% of the total exam. So budget your study time accordingly. You've got this presentation that will be posted on the website. There are some other resources that will be posted on the Utah APA website. Professor Ducker's notes and slides from last year are there now. I assume they will stay there. Readings that you should look at, Land Use in a Nutshell is a good handy reference. A couple of the planning law horn books, what they're called, by Juergensmeyer and Roberts and Dan Mandelker. Those are good resources. If you're really a law nerd and you want to get into the weeds, there's the OIE Project website, which has summaries of, as far as I know, practically every United States Supreme Court case of any note that has been decided within the last 30 or 40 years. So it's very interesting. On this presentation, I will give you the names of cases. I will give you the principles associated with those cases because that's often what the focus of the exam questions is. It will give you a principle and it will say this principle is most closely associated with, and then it will give you the multiple choice answers. Euclid versus Amber Realty, and a host of others. So you will have to understand the principle and be able to associate it with a particular case. So we're going to get started taking a look first at local government powers and where local governments get their authority to regulate land use. The first stop would be the police power. Police power is the inherent authority of states to regulate activities to protect public health, safety, morals, and welfare. This is really the most basic concept of state and local government authority that is associated with most of the ordinances and local regulations that cities, counties, townships, whatever might be your particular local government, forms of government in your state. You notice that I say, though, that states carry the inherent police power authority and not local governments. The second principle you need to understand is that local government is a creature of state government. Local governments only exist in states because they have been created by state government, either through the state constitution or state statutes. So given that, local governments are a creature of state government and that police power is inherently given to the states, there has to be some mechanism for getting police power from the state government down to the local government. That's generally passed on to the local governments most often by state constitution or state statute. It's not true for every local government in every state, however, that every local government has been given police powers. In Michigan, for example, where I used to work for a period of time, counties are not given police powers. They don't have the inherent authority to regulate, to protect public health, safety, and welfare. If a local government has not been given police power, the broad grant of police power, they have to look to specific enabling statutes. Enabling legislation is state law that grants local governments the authority to exercise the powers that they do. So it may come in a broad police power grant through enabling legislation, or it may also come in specific grants of authority. The Standard State Zoning Enabling Act from the 1920s was a model was a model act, a model piece of enabling legislation that when states adopted it, it granted local governments the authority to adopt zoning regulations. That's an example of a specific grant through enabling legislation. Now, a state or a local government can have both. You could have a broad grant of authority, granting broad police powers, the authority to regulate, to protect public health, safety, and welfare. You may also at the same time have specific grants of authority, such as the Standard State Zoning Enabling Act. The questions start to arise when there is a dispute between the local government and the state government as to who actually has the authority to regulate in a given area, in a given subject matter. So there are some rules out there that local governments, that courts have used to try to settle those disputes. The first rule, which dates back to 1868, is called Dillon's Rule. Dillon's Rule is a very strict construction of the authority that is given to local governments. The classic statement of Dillon's Rule is that a local government possesses and can exercise the following powers and no others. Those granted in express words. For example, the Standard State Zoning Enabling Act. Local governments shall have the power to assign land to districts. Those necessarily or fairly implied in or incident to the powers expressly granted. If it's something that the government has to do to carry out one of those express grants of authority, there's just no way to do it without taking on this power as well. I always use the example, the authority to adopt a zoning administrator and put in place rules for zoning administration. You have the express grant of zoning. It's fairly implied that you need to have the administrative tools to do that. And those essential to the declared objects and purposes of the corporation, not simply convenient, but indispensable. These are the essential powers that you need to run a government, okay? Adopt a budget, so on and so forth. If you have been created by the state government, if you're a local government that's been created by the state government, you need to be able to do the things that you have to do to manage your government. Any question about the existence of the power is resolved against the local government. So like I said, Dillon's Rule is an early construction of that grant of authority from state to local governments that is very strictly construed against local governments. Local governments were really disfavored in the 1800s, in the late 1800s. They were considered places of corruption, places where government was not done efficiently or was not done in the public interest. So the early interpretation of that authority skewed against the local government. Your little piece of trivia, which will not be on the exam, Dillon's Rule is named for John Forrest Dillon, who was a justice on the Iowa Supreme Court. And actually Dillon's Rule comes from the 1868 case that was decided by the Iowa Supreme Court. It was so important that they have a monument to him in Davenport, Iowa. That will not be on the exam. Okay, the next principle we want to talk about when it comes to local government powers is home rule authority. Home rule authority came about in the early 20th century as cities got bigger, as cities took on more responsibilities. It was realized that for cities to be able to run professionally, they had to have more freedom than what a Dillon's Rule type of construct gave them. So many, but not all states, many states have given local governments broad powers called home rule authority. They either come through the state constitution or through a series of state statutes, or sometimes both. It's the ability of a local government to act in all areas pertinent to local affairs that have not been specifically reserved by the state. So conceptually, it's almost the reverse of Dillon's rule. That's a simplification, but it's a broad grant of authority to local governments to do what they need to do unless the state says, no, you cannot operate in that particular area. Okay, so a way to think about home rule is as almost the reverse of Dillon's rule. A concept that's associated with home rule is the notion of preemption, when state law supersedes local law. And so there have been some rules that have been construed by local courts or by state courts to decide when home rule, the limits of home rule. When a state law expressly states that it preempts any local law on the subject, that one's pretty simple. When local law in fact conflicts with state law, when there isn't a specific statement that local governments do or do not have this authority, but if there is a state statute that says the state shall be doing X, and then a local government adopts an ordinance that says the local government will be doing X plus Y, and there's an obvious conflict there. And when the state law is so complete, it is considered to occupy the field being regulated. That is where all the litigation comes from, is trying to construe what exactly that means. Sufficient to say that if the state government has set out a broad scheme of regulation, a broad scheme of regulating wetlands, for example, and it is such a detailed description of how it will be done, the courts will consider any local law that also attempts to regulate wetlands as being out of bounds, because the state has determined that it will occupy the field of wetland regulation. Okay. A couple more notions of local government powers, or actually more specifically where the law of land use, some laws of land use come from. The concept of common law. You may have heard the term common law. What common law actually means is that it's often called judge-made law. The common law principles that were created by judges and barristers in England back prior to the time that there was a written code of laws. The traditional unwritten law of England based on custom and usage. So you will hear that some concepts are common law concepts. For land use purposes, the most frequently raised common law concept is nuisance. Nuisance is considered the unreasonable interference with another's rights to use and enjoyment of his land. So when I am growing a tree and the tree hangs over, the limbs from my tree hang over my property line and cause a mess in my neighbor's yard, that can be considered to be nuisance. When a business conducts its business in such a way that there is noise, dust, fumes that interfere with my enjoyment of my property next door or down the street, that could be considered a nuisance. There are two types of nuisances. There's a private nuisance, which would be the examples that I just gave, when one person's conduct of things on his land leads to an interruption of the enjoyment of another person's land. There is also a public nuisance when my conduct results in an interference with a right common to the general public. It interferes with public health, safety, and welfare. Often public nuisances are declared as such by statute. Zoning. Most zoning ordinances say that a violation of the zoning code constitutes a public nuisance because the zoning ordinance itself is designed to protect public health, safety, and welfare, and therefore a violation of the zoning ordinance results in an interference with public health, safety, and welfare. So those are some basic concepts of local government authority. Again, the law portion of the exam is 15% of the total exam. You don't need to be a lawyer to pass the law part of the exam. If you just understand the concepts that we just talked about there, you will have a good start on being able to answer one or two of the questions on the AICP exam. So now we are going to move on to looking at the constitutional limitations on local government powers. And these are the cases, the concepts that most often get associated with planning law. When people talk about planning law courses in planning law programs, when there's a law session at the APA conference, it's these kinds of topics that are generally raised. So the most frequently implicated provisions of the Constitution are 4 sections in the Bill of Rights. The Bill of Rights is the first 10 amendments to the Constitution. The first one is the Fifth Amendment. Fifth Amendment guarantees which are made applicable to states through the 14th Amendment. So we're going to talk about substantive due process, we're going to talk about procedural due process, and we're going to talk about the takings clause. First Amendment guarantees freedom of speech and freedom of religion. We will be talking about those as well. We will also be talking about the 14th Amendment guarantee applicable specifically to the states, the Equal Protection Clause of the Constitution. So we're going to talk about those 3 in particular. You also have another set of constitutional protections out there, and those are the protections that come from your state constitutions. The state courts may interpret their own constitutions to be more protective of individual liberties than the United States Constitution, but not less so. Most state courts in most circumstances interpret their state constitutions the same or very similarly to the way the United States Supreme Court interprets the United States Constitution. Since this is a national exam, we can't get into specific state constitutional protections, but it's sufficient to say that the law of what we are going to talk about here is more than likely the law that's applicable in your local jurisdiction. This is the Due Process Clause, the Fifth Amendment to the United States Constitution. Paraphrase, no person shall be deprived of life, liberty, or property without due process of law. You wouldn't think, just reading that, that you could have so much litigation come out of so few words, but it certainly does. The Due Process Clause has been interpreted by courts to offer 2 separate constitutional protections. The first one we're going to talk about is substantive due process or substantive due process, depending on your preference. Substantive due process protects against arbitrary actions by the government by requiring that a regulation be rationally related to a legitimate public purpose. Those are terms that you will generally hear associated with substantive due process cases. Rationally related to a legitimate public purpose. You will also hear the phrase that government action cannot be arbitrary and capricious. Those all essentially mean the same things. It means that the government has to show that there is some connection between what they are proposing to do and a harm that they are trying to protect from. Okay, it's a very low bar. It doesn't really take too much for a local government to satisfy a substantive due process claim, to be able to show that they meet substantive due process standards. In fact, federal courts don't even like to get into substantive due process cases anymore. They rarely overturn land use regulations on substantive due process grounds. Land use regulations carry a strong presumption of validity. You have to go back quite a few years to find some cases in federal court that implicate substantive due process on with regard to land use issues. A couple that you will probably need to know, or that you need to keep in mind for the AICP exam, are the two that are on the screen now. Welsh versus Swayze, which comes from 1909, which upheld height restrictions that Boston put in place because they had a substantial relation to the objectives of fire safety and public health. The other one, the standard bearer for all land use cases, Euclid versus Ambler Realty, zoning is a valid means of protecting public health, safety, and welfare. These are substantive due process federal cases. A couple that are more recent, where the courts have dealt with the federal court, the United States Supreme Court has decided cases on substantive due process grounds. Moore versus City of East Cleveland, which was decided in 1978. The definition of family that was in the East Cleveland Code that prevented extended relatives from living together did not further a legitimate purpose. We'll be raising this case a little bit later as well. City of Eastlake versus Forest City Enterprises, subjecting a zoning change to a citizen referendum was upheld by the court. It's not an improper delegation of authority, since the authority initially resides with the people in the first place. So in the AICP context, they may give you a principle that says something to the effect that the court case that stated that the definition of family, a definition of family that prevents extended relatives from living together does not further a legitimate purpose. That case is. And they will give you Moore versus City of East Cleveland and 3 others. And so you will need to be able to relate the principles that we talk about with each case. There are other cases that could possibly come up that are substantive due process cases. Berman versus Parker, which we'll talk about later. Hadachek versus Sebastian. The Keystone Bituminous and the Neckdow cases are early substantive due process cases that, if you take a look at the materials that I recommended earlier and that we will talk about again later, you'll be able to get those. I said that substantive due process, that federal courts don't like to get into substantive due process cases. That is not necessarily true in state courts. State courts are more active in striking down land use laws under a substantive due process analysis. The problem with substantive due process is it basically is second guessing on the part of the judiciary. you will see cases, 2 examples. A zoning action violates substantive due process considerations if it fails to advance a reasonable governmental interest. Comes from a Wisconsin case. If it bears no real substantial relation to the public health, comfort, safety, and welfare, including the maintenance of property values. It's a standard that has been stated in Iowa cases. What will be sufficient to understand from the AICP exam perspective is this rational relationship standard, the rational basis, the reasonable governmental interest. Those are all phrases that are associated with substantive due process cases. The next due process, the other due process principle is procedural due process. So we are not looking at the fairness of the law itself. We are looking at the fairness of the process that the government went through before making decisions that affect your fundamental liberty and property interests. So there are 2 primary questions associated with procedural due process. Is there a fundamental interest at work? And is it the type of decision to which procedural due process protections attached? So the first question, is there a fundamental liberty or property interest at risk? Tangible things, such as a parcel of land, that's a fundamental property interest. If you've been through a land use law class, you understand that often property rights are not defined as the tangible thing itself, but also the bundle of rights, the bundle of interests that are associated with the ownership of land. The right to pass over it, the right to sign away mineral rights, liens, so on and so forth. These are all valuable interests that are incident to the ownership of land. Legally enforceable expectancies against the government. It's a concept known as the legitimate claim of entitlement, which I don't anticipate will be on an AICP exam question yet, but there are certainly interesting cases that have been decided over the last 5 to 10 years related to land use, defining what a legitimate claim of entitlement is. Right now it's sufficient to say that a person does not have an entitlement to a specific outcome of a land use hearing, of a discretionary land use hearing. So there's no fundamental property interest at risk, therefore procedural due process protections don't apply. Procedural due process protections don't attach to legislative decisions, which are decisions that are taken by the elected body, actions taken by the elected body. It's considered that the remedy is not the courts in that case, but the ballot box. You can vote them out of office if you feel that you've had an interest that has been implicated. Where this comes into the land use context, a case known as Fasano versus Washington County, which is not a United States Supreme Court case, but an Oregon Supreme Court case. But it's one of the fundamental land use cases that you have to address. If a state court has interpreted a rezoning action to be quasi-judicial rather than legislative, then procedural due process steps have to be taken to protect the landowner's interests. There has to be a fair process put in place for a rezoning. Okay, that is the law in Oregon and a number of other states on rezonings. Is that if Oregon has interpreted rezoning decisions, rezoning requests, and rezoning actions to be quasi-judicial rather than legislative, so procedural due process protections apply. That's not the case everywhere. In Iowa, for example, the court has hinted at the fact that rezonings are quasi-judicial actions rather than legislative actions, but they haven't actually come out and said that that implicates procedural due process protections. What is procedural due process? How does a local government satisfy procedural due process considerations? 6 points. If you provide timely notice of an action that's adequate to inform you that a decision that is affecting your property interests is going to be made. A hearing that provides you an opportunity to present your position and evidence in support of your position, and to hear the positions and evidence of others. Those are the first two. Standards, some sort of criteria in your ordinance or in whatever law you are administering. Standards upon which the government will base its decision, so that it's not just an arbitrary decision. It's just not the whim of the decision maker, but they're using some sort of standards by which they will make their decision. Findings of fact that reflect the information that the decision maker relied upon. The decision maker must be free from bias and conflicts of interest, and there must be some record of the proceedings kept. So if you are in a situation where procedural due process protections apply, you as a local government need to satisfy those 6 principles to satisfy procedural due process standards. Takings. Nor shall private property be taken for public use without just compensation. There aren't too many words there either, but they have generated obviously a tremendous amount of litigation over the past 80 to 90 years. Takings, the takings provision, the takings clause of the Constitution really didn't see much activity until just after the 1900s. And then litigants began to focus more on the protections to individual property and liberty interests that were provided by the takings clause. Anyway, that is it, in case you've ever wondered what the takings clause actually said. It says, nor shall private property be taken for public use without just compensation. The purpose of the takings clause is to prevent the government from forcing some people alone to bear the public burdens, which in all fairness and justice should be borne by the public as a whole. If you're going to take my property for the public, then the public should be paying me for it, if it's for a public benefit. That's sort of it in a nutshell. There are a number of different phrases within the takings clause that are important to break down, because the litigation focuses not necessarily on the takings clause as a whole, but on little segments of the takings clause. So the first segment that we're going to look at is the segment referring to private property. And so what is private property that can be taken? We referred to the bundle of rights. The courts define property rights as the interests that are incident to ownership of land. The bundle of rights, deed restrictions, mineral resources, easements, the right to use, the right to the free use and enjoyment. These are concepts, these are rights that are associated with your ownership of land. So when one of those rights is under threat of being taken by the government, that's when the takings clause is implemented. Is the bundle of rights defined? There is no one list of the bundle of rights, of the rights that are associated with land ownership. They are defined by background principles of state property law. What's in my bundle here in Iowa is likely different than what is in your bundle wherever you're living. A taking of a property right cannot occur if a landowner never possessed that right under state law to begin with. Lucas versus South Carolina Coastal Council, which will come up over and over again over the next few slides. The idea is if it's something you did not possess to begin with, if it wasn't a right that is recognized by state law, you do not have a takings claim when the state government, quote unquote, takes that right away, takes that action. The best example I have is from an Oregon case. This case won't be on the AICP exam, but I think it's very helpful to understand that concept of bundle of rights. Beachfront property owner in Oregon found out that when they took title to their land, background principles of Oregon state property law were that exclusive use of the dry sand area was not a part of what they purchased when they purchased that property. In other words, it gave people a right to traverse to and fro across the dry sand area of the beach, the right of the public to do that, because the landowners didn't own the right to exclude people from that area to begin with. It's never a taking if the government's action is directed at abating or preventing a nuisance. Also from Lucas versus South Carolina Coastal Council. Okay, so those are some concepts that are important to understand when you talk about the concept of private property. Public use. Nor shall private property be taken for public use without just compensation. This has been litigated quite a bit as well. The government has no authority to take at all, even if they're willing to pay just compensation, if property will not be put to a public use. So the court has invalidated government action on the grounds that what the government was trying to do was not associated with a public use or with a public benefit. What constitutes a public use? Public projects are obviously public uses. Public access to land, parks, recreation trails, that is a public use. Those are public uses. The court has said that a use is public for purposes of the takings clause if it's rationally related to a conceivable public purpose. The courts are very unlikely to second guess the government's determination of whether their action is for the public use or is for public benefit. Berman versus Parker, 1954. We're going to go through a string of cases here that will end up with the Kelo case back in 2005. But you can see the string of cases where the court has said we aren't going to second guess a government's determination as to whether the use they are going to put a property to is a public use. An urban redevelopment plan from 1954 that included eminent domain of blighted and non-blighted properties was upheld because the plan was determined to be of a public benefit. State courts may interpret state constitutions to be more restrictive than that. The issue over the takings, the issue over eminent domain that came out of the Kelo case back in 2005. In some states, the courts have interpreted public use more narrowly than what the United States Constitution has interpreted public use to mean. So a state court, for example, in Michigan in 2004, may strike down a state or local government action if the state court interprets the state constitution to say that a public use is more narrowly defined. United States Supreme Court, 1984, a use is a public use even if there is public advantage or benefit, even though the property will not be used by the general public. So that's when the court equated public benefit with public use. Hawaii Housing Authority versus Mitgift is the case that is associated with the notion of a public benefit. It upheld a state law designed to break up the historical land oligopoly by condemning private property and transferring it to the tenants that have been living on the properties, sometimes for tens of hundreds of years. Or the family has lived there for tens of hundreds of years. And then finally, that gets us to Kelo. Kelo versus New London of 2005. This was the eminent domain case that stirred up a lot of discussion, a lot of controversy about 8 years ago. A redevelopment plan in New London, Connecticut that included the use of eminent domain for economic development purposes to basically condemn some properties, not necessarily showing that all of the properties were blighted, condemning those properties, handing the property over by sale to a corporation for a corporation to build a corporate headquarters. The redevelopment plan that included the use of eminent domain without showing that the properties were blighted was upheld by the United States Supreme Court. Kelo versus New London. There were actually 4 Supreme Court cases that were decided in 2005 that are important for AICP exam purposes because the APA considers them to be important cases. This is one of them. This is one of the 2005 cases. We will go through the other 3 as we go along. A permanent physical occupation. The taking occurs when government action results in actual permanent invasion of the land and not merely an injury to the property. That's a given. That one's pretty basic concept. The case that you need to understand, that you need to associate with that concept is the Loretto case, Loretto versus Teleprompter Manhattan, where New York City law forced people to install cable boxes, forced landlords to install cable boxes on their apartment building. The cable box itself was considered to be a physical invasion of the landowner's property, even though the cable box was tiny. So you have permanent physical occupation cases, and then you have regulatory takings cases. These are the cases that receive the most attention. A regulation can result in a taking even if the government never acquires physical possession or authorizes permanent physical occupation. The regulation that goes too far can be considered to be a taking. That comes from the Pennsylvania coal case back in 1922, which is really considered by many to be the seminal regulatory takings case. So you will need to be familiar with the Pennsylvania coal case. There are different types of regulatory takings. A taking occurs when a regulation denies a landowner all economically viable use of the land. That's known as a total deprivation case or a total regulatory takings case. And there's the Lucas case again. South Carolina Coastal Council put a regulation in place, a setback regulation in place that essentially made the property owner's land unbuildable. It's debatable whether it was unusable, but it was unbuildable. It lost all economically viable use. And therefore, the United States Supreme Court considered that a taking, a total deprivation. You can have a taking without a total deprivation. The seminal court case for the multi-factor analysis. If a landowner cannot show that all economically viable use of the property has been taken, but a substantial amount of the economic value of the land has been taken, you go to a multi-factor analysis. You can think of it as a decision tree, and if you don't satisfy the total deprivation standard, you move to the Penn Central standard. Courts look at 3 factors in the multi-factor analysis case. The first being the economic impact of the regulation on the landowner. Okay, you haven't taken away all economically viable use of the land, but you've taken away quite a bit of it. The court will ask, is the economic loss extremely severe? The Palazzolo case, where the regulation resulted in a loss of 93.7% of the value of the property, was not considered a taking when you look at the other set of factors in total. When you look at the next 2 set of factors. The court will also ask, does the landowner gain some reciprocal benefit from the regulation? You look beyond just the constraint of the regulation, but does it give the landowner an advantage as well? The second factor in the multi-factor analysis, the extent to which a regulation interferes with reasonable investment-backed expectations. What did the purchaser expect to gain, expect to receive out of the property when it was purchased? If you purchase a property knowing that there are regulations that will inhibit your use of the property, and that is reflected in the purchase price, then you are purchasing a piece of property with the understanding of those constraints. If you purchase it with the knowledge of pre-existing restrictive regulations, just that knowledge, just the existence of pre-existing restrictive regulations doesn't preclude a takings claim, but it does shape your expectations when you purchase the property. If every other piece of property around yours sold for $100,000, you were able to get yours for $20,000 because it's a unique piece of property that has wetlands, or is next to a shoreline, or has some more restrictive regulations associated with it, then your investment-backed expectations should not be based on what everyone else's investment-backed expectations were for their property, because it was reflected in the purchase price. The third factor, the third and final factor in the multi-factor analysis is the character of the governmental action. What does that mean? It simply means that the court will balance the public need for the regulation against the private cost of that regulation. The Keystone Bituminous case from 1987 out of Pennsylvania, United States Supreme Court case out of Pennsylvania. State law prevented subsidence of surface land caused by coal mining. The coal companies claimed that it was a taking, but the court said that because it only prevented the mining of 2% of all of the available coal, it was not considered a taking, because the public need for preventing ground from essentially caving in, houses caving in, the public need for that weighed sufficiently against the private cost of not being able to mine 2% of the available coal, such that the character of the government's regulation was okay, and it was not considered a taking. Moratoria, the topic of moratoria. We have moved beyond total deprivations and partial deprivations. Now we're looking at specific planning tools, or the constitutional status, I guess, for lack of a better term, the constitutional status of frequently used planning tools. In 2002, the United States Supreme Court said that the enactment of reasonable moratoria in the planning process is not a taking. A taking must be a loss that is greater than just the present right to use the land. They didn't make a blanket statement and say that all moratoria are valid and a moratoria can never be considered a taking. They will look at the reasonableness, the government's good faith, the length of delay, and the actual impact of the delay on the property value. But the Tahoe Sierra versus Tahoe Regional Planning Agency case was a case that was important and favorable to the planning profession. It's a good case for an AICP question. Another one of the 2005 cases that I referenced earlier, San Remo Hotel versus San Francisco. A takings claim cannot be relitigated at the federal level when the issue was previously litigated in state court. The federal court will not hear a takings claim if it has been adequately litigated in the state court. So that is another one of the 2005 cases that would be helpful to keep in mind. Remedies. The first English case stands for the proposition that not only can the offending regulation be invalidated if a taking has been shown, if it has been shown that this regulation confers a taking, but the person bringing the action may be entitled to money damages for even a temporary deprivation. In other words, if you suffer a loss between the enactment of the offending regulation and the date that the regulation was struck down by the court, you may be entitled to money damages and not simply just the invalidation of the law. Exactions. Exactions have come up in the takings context in a couple of circumstances. An exaction is a requirement imposed on a landowner or a developer to pay a fee, provide infrastructure, provide an easement, give up title to property as a condition of project approval. What the court has said is that for an exaction to pass constitutional muster and not violate the takings clause, the government must be able to show that there is a rational nexus between the exaction and the adverse impacts of the project. That is the Nolan case. It's handy because these two cases rhyme. The Nolan case from 1987. The rational nexus concept simply means that what you are asking them to do must have some relationship to the impact of the project on the community. You can't require a completely unrelated exaction from the landowner. The Dolan case took it a step farther. It says that the exaction must not only have a rational nexus to the adverse impacts, but the exaction must be roughly proportional to the burden imposed on the community by the development. That's Dolan versus City of Tigard. So Nolan and Dolan cases are associated with exactions, rational nexus, and rough proportionality. The third 2005 case was Lingle versus Chevron. This may or may not be on the AICP exam, but it is on the chance that it is. Lingle simply said that this idea that we used to have in the United States Supreme Court that if a regulation didn't substantially advance a legitimate state interest, that was a takings. They said we don't agree with that anymore. The United States Supreme Court went back and said that looks too much like a substantive due process case. So that is not a standard that proves takings any longer, because that standard does not help identify those regulations whose effects are functionally comparable to government appropriation or invasion of private property. And so it really clarified takings law for a lot of the planners, a lot of the lawyers that spend a lot of time looking at these things. Again, a 2005 case that might be important for the AICP exam. I think we're going to take just a quick 5-minute break. When we come back, we're going to take a look at equal protection and a couple of other constitutionally related provisions, First Amendment, and then we will finish up. But at this point, we're going to take a 5-minute break by my watch. That puts us back at 10:07. Okay, welcome back. Hopefully you all got your second or third or fourth cup of coffee. We are on the home stretch. We are still talking about constitutional issues, constitutional protections. We're going to take a look now at the Equal Protection Clause of the U.S. Constitution, which says no state shall deny to any person within its jurisdiction the equal protection of the laws. The right of similarly situated individuals to be treated in a similar manner. You have to understand that every law that's in place has to categorize people to some degree, has to apply to some people and not others, or may apply to one category of person differently than others. That in itself does not violate the Constitution. What violates the Constitution is if you are making these classifications, these categorizations based on grounds, based on classifications that the Constitution says are protected. Now, the way I explain it to my class, the way I think it makes some sense, is that if you understand that the government has to make a showing that its law is valid. Think of it as three different hurdles. The more questionable the classification is and is recognized to be by the Constitution, the higher the hurdle the government has to clear to show that that law is valid. Those are considered to be the standards of review for equal protection cases. The highest hurdle to clear is when the government is making its distinctions based on what the Constitution considers to be a suspect classification or a fundamental interest is implicated. If that's the case, then the government's action comes under what's known as strict scrutiny. Okay, and so we will take these one at a time. We will start with strict scrutiny when a suspect classification or fundamental interest is implicated. A regulation may be attacked if it categorizes uses or singles out individuals based on a suspect classification. What is a suspect classification? A suspect classification is one where a history of invidious discrimination has been shown. Making classifications based on race or national origin, or enacting the regulation in such a way that it treats people differently based on race or national origin. Those are suspect classifications, and those types of classifications are not treated well under the Constitution. What's a fundamental interest? A regulation or the application of a regulation may be attacked if a classification is based on a fundamental known as a constitutionally protected interest. Freedom of religion, freedom of speech, freedom of privacy, these are suspect classifications. If a suspect classification or a fundamental interest is implicated, the government has to show that the regulation bears a necessary relationship to a compelling governmental interest. That's considered to be the strict scrutiny standard. And so unless the government can show the necessary relationship to a compelling governmental interest, the law will be struck down. The cases. The first case, the first strict scrutiny case, you have to understand that what someone challenging a law based on a strict scrutiny standard has to show, they have to show that there is a discriminatory purpose to that regulation and not merely that there was a discriminatory impact. In other words, there has to be intent associated with it. There has to be intent on the part of the local government to discriminate based on race, national origin, or fundamental interest. A disproportionate impact, just because it affects different races differently without showing the intent for that to happen, the disproportionate impact alone is insufficient. And that's the Village of Arlington Heights case from 1977. However, under the Fair Housing Act, Congress has gone farther. Congress has gone farther and said that a claim of discrimination under the Fair Housing Act may succeed on a showing of disproportionate impact. You don't have to show intent. You just have to show that the law has a segregative effect or that it makes housing options significantly more restrictive for members of a suspect class than for persons outside of that group. So there's a case where Congress has given greater protections than what the Supreme Court has interpreted the Constitution to provide. So those are suspect classification cases. Those are strict scrutiny cases. There are a few cases in this middle tier, what the court has called quasi-suspect, that's misspelled, quasi-suspect classification. They've been referred to as middle tier cases. There's really no one phrase that describes them. If you have a middle tier case, it is the only recognized middle tier classification, if you will, and it's not really clearly recognized, is gender. If a quasi-suspect classification, if a gender classification has been raised, the local government has to show that it bears a substantial, that their action bears a substantial relationship to an important governmental interest. We're not going to spend much time on that because the law on that is not very clear. All other cases, other than the ones that we just talked about, are rational basis cases. These sound a lot like substantive due process cases because the bar is pretty low. The hurdle that the government has to clear is pretty low. The standard of review for rational basis cases where the classification is not based on a suspect class, a fundamental interest, or a suspect or a quasi-suspect classification. All that the local government has to show is that the law is rationally related to a legitimate governmental interest. Yes, sounds very similar to substantive due process. The Bell-Terre case from 1974, an ordinance that limits the number of unrelated individuals living together was upheld by the United States Supreme Court. So in thinking about the Bell-Terre case, it's handy to contrast it with the Moore case, the substantive due process case that we referred to earlier, where the court did have a problem with the regulation that limited the number of related individuals living together. Bell-Terre says that there was no problem with an ordinance limiting the number of unrelated individuals living together. A couple more rational basis cases. The notion that the rational basis test is not a rule of non-review. By that it simply means that the government doesn't always get over that low bar. There have been rare cases where the court has said that the government hasn't even satisfied that rational basis test. Claiborne versus Claiborne Living Center, 1985. Ordinance requiring a special use permit for a group home for mentally retarded but not other types of multiple unit dwellings was based on an irrational prejudice and violated the Equal Protection Clause. Then the Village of Willowbrook versus Olick, the Olick case, when it's considered the class of one case, where an individual was able to show that he was intentionally treated differently from others similarly situated, and there was no rational basis for the difference. There was an implication of malice on the part of the local government. It's a very short opinion. It may or may not, more likely not to be on the AICP exam than likely to be on the AICP exam, but it fits into the big picture, so you need to know that it's out there. The Fair Housing Act. The Fair Housing Act is often conceptually closely related to the Equal Protection Act. We talked about it a little bit a couple slides ago. Understand that the Fair Housing Act lays out some different, more protective standards for some classes of individuals. In '88, the Fair Housing Act was amended. It makes it illegal to refuse to make reasonable accommodations to disabled renters or buyers. Okay. Cities are exempt from the Fair Housing Act for any reasonable restriction on the number of occupants permitted to occupy a dwelling. Case that you might need to know, City of Edmonds versus Oxford House, 1995. That exemption does not permit cities to close their single-family zones to group homes. Restrictions that the Fair Housing Act exempted by putting that exemption in place were only those that apply uniformly to all residents of all dwelling units. Okay. First Amendment. There are actually two pieces to the First Amendment. There is the freedom of speech provision. There is the freedom of religion. We will take care of each of those. First thing you have to understand is that not all speech is protected speech. There are well-recognized categories of non-protected speech, those that are listed here. Speech that presents a clear and present danger of imminent lawless action. That is not protected by the First Amendment. Speech that urges illegal conduct is not protected by the First Amendment. Obscenities are not protected by the First Amendment. Defamatory falsehoods, none of those are protected by the First Amendment. The question becomes, as we move forward talking about land use, where do we draw the line between obscenities and adult entertainment? So we will get into that a little bit with some of the cases. Categories of First Amendment speech: protected speech, non-commercial speech and expression, political ideas, things of that nature. Those are protected at the highest level. I guess if you were to go back to our hurdle analogy, the tallest hurdle would be speech that implicates, or regulations that implicate non-commercial speech and expression. Commercial speech is protected as well, but not to the same degree as non-commercial speech. Symbolic conduct is also protected. Symbolic conduct would be up there with the taller hurdle, along with non-commercial speech. So we're going to look at each of these. Non-commercial speech. The court decides that when the court looks at a regulation that implicates non-commercial speech, it looks at these 5 factors. Is the regulation regulating merely the time, place, and manner of expression? Is the regulation content neutral? In other words, as long as the regulation does not favor one message over another, it will be okay. Is the regulation narrowly tailored? Does it regulate more speech than necessary? Is there a significant or compelling interest unrelated to the suppression of speech? Are you regulating the secondary effects of the expression? This is where adult entertainment regulations find their validity. We'll talk about that in a minute. And does the regulation allow for alternative avenues of expression? We'll break all of those down when we get into specific topics. Commercial speech. How do we distinguish commercial speech from non-commercial speech? Commercial speech has as its predominant theme simply proposing a commercial transaction. A paid advertisement with a non-commercial message contained in it somewhere is not commercial speech. Advertisers may not immunize themselves from public regulation by including some references to public issues. So here's the slightly lower standard for commercial speech. It comes from the Central Hudson Gas case of 1980. Government may regulate against false or misleading messages. Government may regulate the time, place, and manner of expression. This is where billboard regulations find their validity with relationship to traffic safety. Time, place, and manner, it's important that we regulate the billboards. The substantial governmental interest is traffic safety. So this is where the current litigation over lighted signs, flashing signs, so on and so forth. And is the regulation no more extensive than necessary to serve that substantial governmental interest? So here are the cases. Here are the cases that you need to know. 1981, the Metro Media case has said it stands for the principle that a government may ban off-premises billboards and signs for traffic safety and aesthetics purposes. Metro Media. However, you may not place greater restrictions on non-commercial messages than on commercial messages. 3 more cases. Signs. Los Angeles City Council versus Taxpayers for Vincent, 1984. May impose a total ban on posting signs on public property. Okay. 1994, the Ledoux case. Residential signs are unique forms of communications. In this case, a sign in a residence, in a home, in a window in a house that says "for peace in the Gulf" could not be banned because residential signs, the court considered it to be a unique expression of ideas. In the Lindmark case from 1974, prohibiting real estate signs was invalid because it kept truthful information from the public. I would say that the first 2 cases on this slide are more likely to be on the AICP exam than the last case. Sexually oriented businesses. These are the cases associated with the regulation of sexually oriented businesses. The rationale of using zoning to regulate location, size of sexually oriented businesses is that you are not regulating the action or the speech itself. You are regulating to reduce the secondary effects of the speech. Crime, prostitution. If you have studies that show that these types of uses raise the incidence of crime, prostitution, drug dealing in a neighborhood, then your regulation is valid because you're reducing those secondary effects and you're not restricting the speech itself. Young versus American Mini Theaters, 1976. It is okay to use separation standards to say, for example, that any sexually oriented business or any adult entertainment business must be located 1,000 feet from a school, from a park, from a playground, so on and so forth. That is why so many of our sexually oriented business regulations at the local level use that type of an approach, use 1,000 feet, 500 feet, so on and so forth, because of Young versus American Mini Theaters, because it was the first case to say that that is okay. Renton versus Playtime Theaters, it is okay to restrict businesses to a tiny place in your municipality. However, you cannot completely eliminate them from the jurisdiction. You don't have to make sure that the land is available, that they will automatically be able to locate a sexually oriented business in that tiny corner of your municipality. They still have to be able to compete in the real estate market. So you don't have to make sure, you don't have to guarantee them a place in your community. You just have to zone it in such a way that it is not, that they are not completely zoned out of your community. That's Renton versus Playtime Theaters. City of Erie, 2000 case that upheld a regulation banning complete nudity, and Los Angeles versus Alameda Books. A little glitch in their ordinance allowed multiple sexually oriented businesses to locate in the same building. They went back and fixed that ordinance, and the court said that fix was okay. When the city relied on studies from other communities and not their own studies to substantiate the negative secondary effects, the court said that was okay. You can use studies from other communities that are reasonably believed to be relevant when you are trying to show that there are secondary effects associated with the sexually oriented business that you are regulating, the type of business that you are regulating. That's why all of your communities don't have their own studies, and that's why when you look in the opening clause of your sexually oriented business ordinance, it says we relied on studies from Los Angeles, from Phoenix, from X, from Y, from Z to make the determination that this ordinance is necessary. Okay. The other First Amendment clause, the freedom of religion. There are actually two parts to the freedom of religion clause. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. So the establishment clause says that government cannot advance or promote the establishment of a religion. It's where the concept of separation of church and state comes from. The free exercise clause, nor can a government inhibit the practice of religion. A neutral law of general applicability is okay if it places only an incidental burden on religion. You won't be expected to know that there was a case from 1980 from Oregon that established that principle, that if the law does not call out religion on its face, if it has general applicability, it's okay even if it places incidental burdens on the practice of religion. As a result of that case from 1980, we got the Religious Land Use and Institutionalized Persons Act, or RLUPA, where all of the litigation regarding land use and religion is taking place and has taken place for the past several years. The principles of RLUPA. Local government shall not, or any government shall not impose a land use regulation that places a religious assembly on less than equal terms with a non-religious assembly or institution. If it is conceptually the same type of land use, theaters and churches have similar characteristics. Think of the land use characteristics. You cannot treat them differently just because one is a church, but if they have functionally similar land use characteristics. You shall not impose a land use regulation that discriminates against assembly or institution on the basis of their religion. That one's pretty obvious. You cannot totally exclude religious assemblies from your jurisdiction, another obvious one, or unreasonably limit religious assemblies, institutions, or structures within a jurisdiction. It starts to get a little more complicated. And here's the one where most of the litigation takes place. RLUPA says that no government shall impose or implement a land use regulation that imposes a substantial burden on religious exercise unless the government shows that the burden is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that interest. What you should have picked up by now is that a lot of these constitutional standards read similarly. This reads similarly to the First Amendment freedom of speech standards for non-commercial speech. The one case that I think is most important to pick up in the RLUPA context, at least until they do a substantial rewrite of the exam, is the Club versus Chicago. A substantial burden is one that necessarily bears a direct, primary, and fundamental responsibility for rendering religious exercise effectively impracticable. That's a pretty high burden for someone suing a local government on a RLUIPA claim to show. That's definitely a standard that favors the local government. Okay, we're going to move into a few topical issues, and then we will take our questions. These are issues that are frequently raised on the AICP exam. The first one is exclusionary zoning. These are the miscellaneous cases that we talked about before. Exclusionary zoning is when you use zoning to exclude legal, legitimate land uses and land users generally. Okay, group homes, manufactured housing, junkyards, NIMBYs, LULUs, industrial uses. It applies broadly. It's intended to apply, the phrase applies broadly to a number of practices. The constitutional principles that are implicated in exclusionary zoning cases, you can already imagine what they are. Equal protection cases, substantive due process cases, where exclusionary zoning is a practice, for example, is a way to zone out on the basis of race, zone out on the basis of religion, equal protection claims, and substantive due process claims. What are the statutory remedies? We've already talked about one, the Fair Housing Act. Your state may have a similar type of enactment for fair share housing, or state enactments for fair share housing itself. Beyond fair housing, what we're talking about with fair share housing is making sure that each community take its proportional responsibility for supplying low and moderate income housing needs. You may have state enactments that protect particular land uses that preempt the local exclusion of manufactured housing, for example. Judicial remedies. In some states, regulation, an excluding regulation does not receive a presumption of validity. The Mount Laurel cases from New Jersey, where the New Jersey courts interpreted the New Jersey state constitution to read to require communities to take their fair share of regional housing needs. Aesthetics. Can we regulate based simply on aesthetics? The question is a substantive due process question. Does the regulation promote public health, safety, and welfare? In some states, state courts have interpreted their constitution to say, no, aesthetics alone is insufficient grounds for regulations. You've got to regulate beyond just pretty. Okay, there has to be some other basis for regulation beyond just pretty. However, a growing number of state courts goes along with Berman versus Parker, which says that aesthetics alone are a valid concern of public welfare. Berman versus Parker, this gets cited all the time as supporting regulation based on aesthetics. Public welfare includes values that are spiritual as well as physical, aesthetic as well as monetary. It is within the power of the legislature to determine that the community should be beautiful as well as healthy. So in other words, regulation for aesthetics is a legitimate public purpose. Okay. Couple of federal, or one other federal enactment. The Federal Telecommunications Act. What are we dealing with here? Cell towers. Okay. The FTA goes back to 1996. What can local governments do under the FTA? Local governments can regulate the placement, construction, and modification of personal wireless services facilities. An amendment to the FTA back just a couple of years ago says that a local government must approve or shall approve requests for a modification of an existing wireless tower or base station that does not substantially change the physical dimensions of such a tower or base. So in other words, you have to approve the application when all the application is to add an additional antenna onto a tower. If you're not changing the height of the tower or the size of the base station of the top of the tower, all you're doing is hanging all they're requesting is a new antenna. You've got to approve that. So local governments can regulate the placement, construction, and modification of cell towers. Local governments cannot discriminate among providers of functionally equivalent services. Local governments cannot ban wireless service facilities altogether. They cannot prevent service from being provided to an area. This is where most of the litigation is. And the litigation is all over the map from federal circuit to federal circuit in terms of what does it mean to when it says you cannot prevent service from being provided to an area. It's so all over the map that there should not be an AICP exam question on the topic because I don't know what principle they would be testing on. You cannot regulate on the basis of the environmental effects of radio frequency emissions. In other words, Congress has already made a determination that there is enough scientific evidence out there that the radio frequency emissions from a tower are not harmful to human health. They've already made the determination that they're not, and so any entertainment of such an argument at the local level is not allowed to stand. Local governments must act on applications within a reasonable period of time and issue written decisions supported by substantial evidence contained in a written record if a permit is being denied. The first point, act on applications within a reasonable period of time. This won't be on the May exam, or should not be on the May exam, as I understand what their exam refresh is going to be. They're going to refresh the exam in November and add a few new questions. So this could be on the November exam. I don't believe it would be on the May exam. The cell tower shot clock. The FCC has set presumptive time limits based on what the FCC considers to be reasonable, going back to the notion that applications must be acted on within a reasonable period of time. What the FCC says is that local governments have 90 days to act on requests for co-locations and 150 days for all other types of applications. And a failure of the local government to issue a decision within those time periods is considered a failure to act, which will allow the applicant to sue the local government. There is a case in front of the Supreme Court right now, City of Arlington, Texas versus FCC. That is an issue of the FCC's authority to issue this ruling. It's not decided yet. Arlington versus FCC probably will not be on any AICP exam anytime real soon. The fourth 2005 case that we talked about earlier, Rancho Palos Verdes versus Abrams. Federal Telecommunications Act claimant is not entitled to seek remedies beyond those that are specified in the Federal Telecommunications Act. In other words, a cell tower company cannot seek monetary damages for a lengthy delay because monetary damages is not one of the remedies that is allowed for in the FTA. So there is your fourth 2005 case. Sweeping up the last little bits here, growth management techniques. You know, I know I said previously that we aren't going to talk about growth management techniques. What we are going to talk about are cases that have been associated with growth management techniques that have been put in place. Impact fees. You should know what impact fees are. They are when charges are made for new development for burdens placed on public services such as water, roads, parks, fire protection. Think about it in the Nolan and Dolan context. Rough proportionality and essential nexus is obvious, but rough proportionality will require some individualized calculation. We are charging water infrastructure fees based on the square footage of structures or the number of bedrooms or something that allows an individual calculation of the burden that that particular development is placing on the community. To meet the rational nexus challenge, the fee must establish that the level of service must establish the level of service or capacity of the facility which the impact fee scheme is designed to maintain. In other words, there has to be some relationship between that fee and what they expect to be doing with the sewer plant. You can't charge a fee that will ultimately lead in a huge revenue generation for the community. It's got to be a fee that is associated with the facility that is burdened. That the level of service is consistent with other parts of the comprehensive plan, setting forth development densities, intensities, so on and so forth, to show that there has been some relationship made to figure out the overall burden that will be placed on the community's infrastructure over time by all of the development contemplated in the comprehensive plan. Here are the cases. We're no longer dealing with impact fees. Here we're dealing with timing and phasing growth management controls when you link approval of new development to the availability of adequate public facilities. That's the Ramapo case from New York. There was an 18-year plan for phased development of the town. The permit was issued only if the developer could show the availability of 5 essential services. The court has said that the Ramapo scheme passed constitutional muster. That the scheme as it was put together bore a rational relationship to the protection of public safety and the provision of public services. Development quotas. It's when there is an annual cap placed on the number of permits issued. That's the Petaluma case from California from 1976. The court upheld development quotas in the Petaluma case. The permit issuance was based on a scoring system with points awarded for design, provision of recreational facilities, etc. It was upheld because it wasn't simply the first 500 people in the door on January 1st. There was a rational scheme put in place for deciding which of the applications were the best 500 for the community, if you will. Okay. Urban growth boundaries. Boundaries drawn around municipalities that define geographic limits of municipal growth. Contrast with defined service areas, which is a designation of where the municipality will or will not extend infrastructure. State court cases have upheld both of those. Transfer of development rights, separating the right to build on a parcel and giving that right to a separate parcel. So separating the right to build on a parcel A from parcel A and giving it to parcel B. The idea is that you are preserving property or an area from development or overdevelopment, but you're still giving that landowner the economic development that would be associated with the right to build. generally you have to have some state enabling legislation in place for a local government to enact a transfer of development rights scheme. And so conceptually, there's what it is. All 4 parcels have the right to develop to 10 dwelling units per the acre. In a transfer, under a transfer of development rights scheme, A1 could sell 5 units of development rights to B1 in a monetary exchange, or in the example, A2 could sell all of her development rights, all 10 of its units, to B2, which would allow B2 to develop at 20 units to the acre. That's what we have. That is it. That is a 3-credit land use law course in an hour and 45 minutes. Again, here are some resources that I think will be helpful for you as you get ready for the exam. And with that, we'll see what we have for questions.
Hello?
Hello.
Yeah, we have one question from Karen. Can you clarify what upheld means in the Kelo case?
In the Kelo case?
Yeah.
Upheld means that the United States Supreme Court found that the use of eminent domain to take private property and give it to a private corporation for private development purposes was okay. They had a redevelopment plan in place, and part of the redevelopment plan required the exercise of eminent domain to take private property. Upheld means that the Supreme Court found that action was a valid action and didn't violate the Constitution.
Thank you. And that was it for the questions. We'll wait for maybe 3 to 5 minutes for more questions.
Okay.
Next question is, please review the importance of Lynch versus Chevron again, please.
Lingo versus Chevron?
Yeah.
Yeah, Lingo versus Chevron, the importance of it is simply that what used to be considered, what the court used to accept as a standard for showing a taking, they no longer accept as of 2005. It used to be that they would entertain a takings claim, a claim that, let me see if I can get back to. They used to accept as a takings claim a claim that a regulation did not substantially advance a legitimate governmental interest. And so the court simply said, you know, that looks too much like so many of our other substantive due process standard, or our other substantive due process standard, and it really doesn't fit with the notion with what we've described as total deprivation cases, as partial deprivation cases. So we're going to limit takings types of cases just to those types: total deprivation cases, physical invasion cases, multi-factor analysis cases, which are Penn Central cases. Beyond that, that is it. It did not create a new type of taking. It actually pared down the types of takings claims that there are out there.
Thank you. Next question from Megan. Could you give another example of what kind of question they might ask about the court case or a topical issue?
Sure. Let's see, an example of a court case and a topical issue could be something related to a growth management. They give you a growth management scheme, like a development quota, and they will say that this concept, this growth management technique, this type of growth management technique has been upheld in the case of blah, blah, blah. And so then they will give you a list of 4 cases, and you will have to be able to pick out you'll have to be able to pick out the correct case. Another type would be a comparison. I think a comparison type of situation. I'm thinking in terms of the First Amendment arena, for example, comparing an example of non-commercial speech to an example of commercial speech, and they might ask you which has greater protection under the First Amendment. Or they will ask you a case, one of the cases that I pointed out associated with the First Amendment, and say which is entitled to greater protection. I suppose a third example would be they would give you an example of a regulation on an adult entertainment establishment, or a regulation controlling adult entertainment establishments, and they will ask, and in the multiple choice they will say you can regulate this based on the notion of reducing secondary effects, which would probably be the right answer, or then give you three other phrases unrelated to the First Amendment, or something to that effect, phrases related to equal protection. So they could really spin them a number of different ways, but as long as you are able to relate the case to a concept, and you are able to understand the distinctions between the concepts that we talked about today, you'll be okay.
Thank you, and we'll wait a couple more minutes for questions. Okay, I don't think we have any more questions. Do you have anything to add before we end, Gary?
I don't.
Okay.
Thank you.
All right. Thank you very much for exam review, Gary, Angela, and Lauren, for hosting this. And thanks everyone for coming.
The organizer has ended